Good morning, even good afternoon, everyone. Welcome to the first webinar of our three-part series, which will provide an overview of the key construction contracting aspects relating to payment, variation and time. In particular, these webinars will highlight best practice in relation to these aspects and provide insight into avoiding disputes. Before we begin, there are a few housekeeping matters to address. To minimise background noise, I've attempted to place you all on mute. But if you could please check if you are on mute to avoid background noise, because we can hear a couple of you at the moment. If you'd like to ask questions, please do so using the webinar chat function. In order to keep within the 30 minutes, we'll be answering as many questions as we can at the end of the presentation, rather than as we go along. So the first webinar today will exclusively focus on the payment and valuation process in typical construction contracts. We do have a bank of previous webinars with some introductory content on construction contracts, which may be useful to you depending on your current experience. These can be found on our S&W YouTube channel or on Vimeo. So I am Lee Hurd, an associate specialising in construction and engineering dispute resolution based in Edinburgh. I am joined today by my colleague Antonia Pacitti, who is a solicitor specialising in property and infrastructure dispute resolution, also based here in Edinburgh. We regularly advise on a wide range of projects and have extensive experience of payment disputes in the construction industry. This experience forms the basis of what we will share with you today. I will now pass you over to Antonia, who will run through the agenda for today's webinar.
Thanks, Lee. Today we will outline payment and valuation approaches under the Construction Act and scheme. Thereafter, we will examine how these requirements are applied to two of the most common suites of construction contracts, JCT and NEC. We will conclude with some best practice tips and contractual management, which should aid you in minimising the likelihood of disputes in your businesses. I will now pass you over to Lee, who will take us through the payment process requirements in the Construction Act and scheme.
Thanks, Antonia. So starting with payment in the Construction Act and scheme. Payment is recognised as perhaps the most important and often one of the most contentious aspects of a construction contract. The valuation, duration and complexity of projects can pose challenges. As the industry has often witnessed, issues such as late payment or optimistic pricing can quickly cause cash flow problems in the industry, with devastating effects for contractors and employers alike. The Housing Grants, Construction and Regeneration Act 1996, as amended, is the main piece of legislation that governs construction contracts and is commonly referred to as the Construction Act. Please note that the first thing you should do before considering whether you need to comply with all the Act's various payment provisions is to actually check that the Act covers the contract that you're dealing with. So checking that your contract is a construction contract, as there are some notable exceptions under the Act, such as oil and gas. The Act requires a construction contract to have an adequate mechanism for payment and sets out a number of mandatory requirements in sections 109 to 113. Crucially, where a construction contract does not contain payment rules, or where it only partly complies with the mandatory requirements of the Act, the relevant clauses within Part 2 of the Scheme for Construction Contracts Scotland, Regulations 1998, will be implied into the contract as if they made up part of the original terms agreed by the parties. In this manner, the scheme provides a kind of fallback position, filling in the gaps where a payment clause in a construction contract is lacking. This approach can be contrasted with the approach to adjudication in the Act and scheme, which is that if one or more parts of an adjudication mechanism in a contract isn't Act compliant, then that whole clause falls out and the scheme provisions apply in full. For payment, the Act is clear that the scheme will only be used to correct the non-compliant parts of the mechanism, but will leave the rest of the payment clause as the parties intended. Antonia will now outline the key payment mandatory requirements under the Act and scheme. These can also be seen on the slide and diagram in front of you.
Firstly, according to Section 109 of the Act, if work is agreed or estimated to be over 45 days in duration, the contractor is entitled to stage or interim payments. The parties are free to agree the amounts of the payments and have complete discretion over payment intervals. If parties do not provide for interim payments in these circumstances, the scheme applies. Under the scheme, a 28-day payment cycle is implemented, and the amount for each interim payment is the value of the work performed less any payments made to date. The second mandatory requirement, Section 110, relates to due dates for payment. The Act states that there must be an adequate mechanism for determining what payments become due and when, as well as a final date for payment. There are two common situations where payment provisions will fail this test. Firstly, if the due date is linked to the giving of a payment notice to the payee from the payer or a specified person. This is to prevent the payer abusing the payment process by not issuing the relevant notice. Instead, the date should either be fixed, such as a set date in the month at fixed durations after the start date, or linked to the actions of the payee only, such as making an application for payment. Secondly, payment cannot be linked to the performance of obligations under other contracts. Should parties not provide for a due date, or there are the above issues with the due date mechanism, the fallback provision in the scheme applies. This is that the due date for interim payments is the later of 7 days after the expiry of the 28-day cycle or the making of a claim by the payee. For the final payment, the due date is the later of 30 days after completion of the works or the making of a claim by the payee. It is interesting to note that, under the scheme, the due date for either an interim or final payment is dependent on the payee making a claim. It is important to remember that interim and final payments should be treated separately under your contract, as they have different valuation approaches under the Act and the scheme. Depending on which contract is being used, interim payments are calculated based on the value of the work to date, which may mean remeasuring works carried out in a particular period, i.e. in a remeasurable contract, or justifying completion of a certain task or activity if operating a payment milestone mechanism. In contrast, the final payment made under any construction contract is generally based on a full reconciliation of works carried out under the contract within the valuation rules for that type of contract. The Act is not prescriptive on the duration for the final date for payment, so parties are free to agree whatever period is appropriate for their contract. If parties fail to provide for a final date for payment under the scheme, the final date for payment is 17 days after the due date, which is usually only 12 days after the payment notice is issued. As these timescales are pretty tight, parties should ensure their final date for payment is drafted clearly to avoid the scheme applying where such timescales would be problematic.
Thanks, Antonia. So now moving on to payment notices themselves. Sections 110A and 110B of the Act deal with the requirements for payment notices. These are issued by the employer, or sometimes the project manager or contract administrator, architect, in a normal construction contract, and by the contractor in a subcontract. Under the Act, a payment notice must be given not later than 5 days after the due date. In our experience, most contracts will simply just adopt this 5-day period. Payment notices themselves must specify the sum that the payer, who's normally the employer, considers to be due and the basis on which that sum is calculated. There have been several cases on what is required to satisfy that test, i.e. the basis on which that sum was calculated. Our advice is, if in doubt, add more detail and don't forget to attach any vouching or documentation referred to. So, what happens if a notice is not given or is given late? Well, the Act provides that a construction contract needs to allow for this eventuality and give the payee an opportunity to be paid. The Act provides that the payee can issue a default payment notice in place of the missing or late notice. In some contracts, this requires a further notice to be given by the contractor or subcontractor, and in other contracts, the payment application, if there is one, simply becomes a default notice automatically without further action from the contractor or subcontractor. The final date for payment is paused for the period after the payer ought to have issued the payment notice and when the payee actually issues a default pay notice, if it's required to do so. These default notices or payment applications which have become the default notice will establish the notified sum that's required to be paid by the final date for payment, subject to any notice of intention to pay less, referred to as a PLS notice. The rationale for having these default notices is so that the inaction or failures of the employer, or project manager or architect, do not result in a contractor and the rest of the supply chain not being paid. I mentioned a PLS notice a few moments ago. PLS notices are covered by Section 111 of the Construction Act. Previously, these were referred to as withholding notices, but should now be referred to as PLS notices. The Act provides that if the employer wishes to pay less than a notified sum before the final date for payment, it must serve a PLS notice. The PLS notice must set out the sum the payer considers to be due on the date the notice itself is served, and again the basis for that calculation. In practice, this is sometimes used if the employer has missed the date for the payment notice and the contractor's application has become the notified sum by default. Under the Act, the PLS notice has to be issued before the notified sum has been established, after the notified sum has been established, but before the final date for payment. There are no prescriptive timescales for these under the Act, and we commonly see anything from 7 days before the final date for payment to only 1 day before. However, should your contract not provide for PLS notice timescales, then under the scheme it's the 7-day timescale that will apply. Overall, although the Act requires an adequate mechanism for payment, you can see there's quite a lot of scope for flexible and a bespoke approach to payment within your contracts. As we've just discussed, there are really 3 main areas that allow parties to tailor their approaches to drafting. Firstly, if staged payments are required, parties are free to agree the amounts and how the amounts are calculated and the intervals for those payments. Secondly, parties can decide the period between the due date and the final date for payment. And finally, parties are free to decide the period prior to the final date for payment for when a PLS notice needs to be given. So long as the parties comply with the Act, our view is that the courts will be hesitant to touch any of these areas of flexibility. For example, if a party strikes a bad deal, such as agreeing to a long period between the due date and the final date for payment, we consider this as something that the courts will likely not get involved in, as long as it's not contrary to the Act. A general point we'd like to make for all the drafters out there is to double check your payment clause has all the relevant components and that they comply with the minimum requirements of the Act. Most of the disputes we tend to see on payment relate to non-compliant provisions and the knock-on consequences that these tend to have on the whole mechanism. So now that we've looked at the legislative background, Antonia will discuss how these principles are applied in the first of our 2 main types of construction contracts.
Thank you for that, Lee. So the first suite of contracts we will discuss today is JCT and SBCC. As many of you will be aware, SBCC is the Scottish equivalent to JCT, and we will be using these terms interchangeably for the purposes of this webinar, as there are no major differences in the payment provisions. This webinar will focus on the 2016 suite of JCT contracts. The key change between JCT 2011 and 2016 in terms of payment provisions was the introduction of a new term, the interim valuation date, which we will refer to as the IVD, which is intended to be incorporated into all contracts down the contractual chain. This change was triggered by the government's Construction Supply Chain Payment Charter by speeding up the payment process throughout the contractual chain so that all parties are paid within the same 30-day cycle. Across the JCT suite of contracts, payment provisions are contained within Clause 4. There has been an effort to simplify the payment and valuation mechanism and to ensure a consistent JCT Construction Act compliant approach throughout the supply chain. The parties specify in the contract particulars what the first IVD will be. Thereafter, the IVD occurs on the same date each month. If parties fail to specify the IVD, the default is that it will occur 1 month after the date of possession. The date of possession is a specific date also set out in the contract particulars. The due date, which triggers the payment cycle for all interim payments, is now 7 days after the IVD. The final date for payment is then 14 days from the due date, and PLS notices must be served no later than 5 days before the final date for payment. However, these dates are often amended by the employers, and so parties should ensure that the dates they are working with are correct to avoid missing any important milestones. The contractor can make an application for payment at any time before the IVD. As I've just mentioned, the next stage in the payment process is that the due date is 7 days after the IVD. 5 days after the due date, the employer must issue a payment notice. As we mentioned earlier, nearly all construction contracts provide for this 5-day timescale for the payment notice. The payment notice specifies the sum that the employer considers to be due to the contractor on the due date and the basis upon which that total has been calculated. Notice that this mirrors the wording in the legislation. Subject to any PLS notice being issued, the employer must pay this amount before the final date for payment.
In this regard, we just wanted to flag that there is a difference in the D&B contract, design and build contract that is, in the SBCC, which should be noted from the standard building contract. The D&B contract remains contractor-led in the payment process. So if an interim application is not received by the IVD, the due date for that month shall be 7 days from the date when the interim application is actually made and received by the employer. In comparison, under the standard building contract, the contract administrator, which is normally the architect, must issue the interim certificate for that cycle, regardless of whether a payment application has been submitted by the contractor. If this is not issued, the contractor may issue a default payment notice at any time after the last date for the issue of that interim certificate. It's also worth mentioning that milestone payments are common in JCT contracts, where the contractor will be paid when a certain task or activity is completed. Note that under JCT 2016, the contractor is now permitted to submit applications for payment on a monthly basis, notwithstanding them only becoming contractually entitled to payment for the work stage when the entire work stage has been complete. This is meant to improve cash flow between the employer and the contractor.
Moving on now to the final certificate under JCT. A final certificate will be issued no later than 2 months after whichever of the following events occurs last: the expiry of the rectification period, the date of issue of the making good defect certificate, or the date whereby the EA or CA issues copies of the statement of ascertainment to the contractor that has to be prepared under clause 4.5.2. The final certificate will state that the contract sum as adjusted throughout the contract and the sums of amounts previously stated as due. If there is a difference between the two sums, then this will become the amount due to the respective party. I will now pass you back over to Lee, who will examine payment provisions in another widely used suite of contracts, NEC.
Thanks, Antonia. First, as a preliminary point, we do have a number of introductory webinars on NEC that give an overview of the NEC philosophy and key clauses. If you're an NEC enthusiast, we'd encourage you to listen to those on our YouTube channel. This webinar, though, will focus solely on the payment provisions. The NEC 3 suite of contracts was replaced in June 2017 by NEC 4. However, in our experience, it's still that NEC 3 is being used by practitioners and remains the most relevant in terms of disputes. We'll therefore focus on the NEC 3 suite today, but endeavour to give you a flavour of the main differences between the two. NEC, as you will probably know, provides for 6 different main options, catering for a range of pricing and payment approaches. These options are helpful in accommodating different basic allocations of risk between the employer and contractor, whilst maintaining consistency in procedural matters with the core clauses. The 6 main options are on the slide there. Option A being the activity schedule, option B being a price contract with bill of quants, C, a target contract with activity schedule, D, a target contract with bill of quants, E, a cost remeasurable contract, reimbursable contract even, and F, a management contract. So just to take through those quickly, an activity schedule simply describes the works and activities that a contractor must perform in sufficient detail to allow the contractor to price the work. An activity schedule sounds quite prescriptive, but can allow the contractor considerable freedom. In contrast, a traditional bill of quants requires the contractor to price each element of the work. Using a simplified example, if an activity schedule requires the contractor to build a wall with given dimensions and characteristics, the contractor may be able to build that wall using many different materials or techniques. However, a bill of quantities will typically refer the contractor to particular materials and equipment, which will then obviously dictate the technique to be employed by the contractor. For the price contracts, options A and B give the client a lump sum contract price for the works. As we'll discuss in the next webinar, this can change if a compensation event occurs or the client varies the work. In target contracts, the parties agree a target price for the works. In addition, they agree their respective shares of any savings made if the true price of carrying out the work is less than the target price or any overrun is exceeded. Options C and D therefore provide a means by which the cost risk is shared between the parties, which is sometimes referred to as a pain-gain share mechanism. In option E, this is the cost reimbursable contract, the client carries the cost risk as parties agree levels of the contractor's overheads and profit, and then pay actual cost plus the agreed levels of overhead and profit. And finally, in terms of option F, the management contract, this is essentially another cost reimbursable contract, but the risk allocation can be varied by choosing the appropriate main options in the subcontracts. This option should only really be used by experienced clients advised by experienced project managers.
Under each of the NEC options Lee has just explained, the contractor is entitled to the price for work done to date, or PWDD, following each assessment date. This is calculated differently for each option. Under option A, each activity in an activity schedule is priced and following each assessment, the contractor is paid the price for each activity as it is completed. Similarly, for option B, you pay for quantities of completed work be measured at bill of quantities rates and proportions of lump sums. Under options C through to F, you pay the defined cost of work done plus fee, which you will note is not linked to the activity schedule or bill of quantities. What we can see from looking at all of the options together is that defined cost is a key concept in each of the options. Although not relevant for pricing the works in options A and B, it is still relevant for assessing compensation events. We shall discuss this in our second webinar in this series, which will focus on variations, claims and compensation events.
So after assessing what option you're dealing with, where is it you actually look for payment information in NEC 3? Well, the answer is in various places. Rather unhelpfully, you have to look in a number of places to obtain the full payment information for an NEC 3 contract. The contract data part 1 contains a lot of crucial specific payment information, such as the assessment interval, the final date for payment, and the start date. The clauses in section 5, such as clause 50 and 51, will outline the payment process itself. And finally, there are other add-ons, such as the YUK2 clauses, which contain information on PLS notices and the due date. There's also then the Z bespoke amendments that could vary any of the above and sometimes add in a more detailed payment application mechanism. We don't propose taking you through every relevant clause in NEC 3, as these are often amended as well, but we thought it was worth briefly discussing the content of Section 5 in the contract, which stipulates timings and the steps to be taken by the parties.
Thanks, Lee. So, as with the JCT building contract, the payment process in NEC 3 is led by the project manager. The project manager has to assess the amount due at each assessment date. The first assessment date is either agreed between the parties at the outset or is the assessment interval after the starting date. This can sometimes be confusing and is often what we are asked to review at the beginning of any dispute. The answer is to look at contract data part 1. It will give you the starting date and the assessment interval so you can work this out. Later assessment dates then occur at the end of each assessment interval until 4 weeks after the supervisor issues the defect certificate and there is an additional assessment date at completion of the works. As we mentioned previously, the amount due is based on the price for work done to date, PWDD, which differs between the various main options. In assessing the amount due, the contractor will also consider the project manager will consider any application for payment made by the contractor. The project manager then certifies payment within 1 week of each assessment date, and the first payment will be the amount due. Subsequent payments will be the change in the amount due since the last payment certificate. Each certified payment is then made within 3 weeks of the assessment date or within the period specified in the contract data. Interest will be due on any late payments if the project manager fails to issue a certificate when he should do so. In our experience, there is often confusion around the final assessment in NEC 3, as there is no final account process as such, like there is in FIDIC or GCT. If you are drafting and wish more detail around the final assessment, this can be added in your Z clauses.
So we mentioned at the start of this section we'd flag some of the main differences between NEC 3 and NEC 4. In the time today we're not able to cover all the changes comprehensively, but if operating an NEC 4 contract you should also consider your contract carefully and consider consulting either internal or external legal if you have concerns. However, for the purpose of today, the first key difference between NEC 3 and 4 is that NEC 4 seeks to rectify the confusion over the final account process by providing a final assessment clause. Importantly, the project manager must make the final assessment not later than 4 weeks after the defect certificate is issued. If the PM misses that date, the contractor can issue its own assessment. Another fundamental change is that NEC 4 actually requires the contractor to submit an application for payment before each assessment date, rather than the process being driven by the project manager. This is designed to avoid disputes and foster a more collaborative approach to payment. NEC 4 also has a few optional X clauses for payment, such as option 22, which entitles the contractor to a bonus if the total cost of the project comes in below the employer's original budget. As I mentioned a few moments ago, these are only a few of the key differences, but all we could cover in the time today. So that completes our discussion of the NEC suite on payments. Antonia will now share some best practice tips and advice for good contractual management.
Firstly, it is absolutely imperative to get the contract right at the drafting and execution stage. For instance, in NEC contracts, it is essential that the contract data is filled out fully and accurately with the appropriate W, X and Y options being selected. Similarly, in GCT contracts, the intention of the IVD is to harmonise payments throughout the contractual chain, but this can only work in practice if it is used across all tiers of the project. Often, as you progress down the contractual chain, the use of standard form contracts becomes less common and the potential benefits of the GCT style is lost. It is very common to see amendments of the standard form, so you should be vigilant to this and take action accordingly, such as re-diarising due dates for payment and notice deadlines. Additionally, if amending the standard form yourself, try to ensure consistency in form and structure. For instance, it is advisable to follow the original contractual structure as much as possible by inserting any payment amendments into the payment clauses themselves. After this initial stage, and especially in NEC contracts, the contract should be conscientiously managed rather than being locked in a drawer out of sight and out of mind. Emphasis should be placed on managing the valuation process as work is ongoing, as it is when this process is not managed properly that parties end up in dispute. Many of you listening today will be aware of smash and grab adjudications. These arise where payment notices are not issued in line with the requirements of the contract and the payment application becomes due for payment even if the employer considers the amount is not correct. Following recent case law, these types of disputes are currently in decline, with some commentators hailing the end of the smash and grab era. However, it remains essential to ensure that notices are given on time and that they comply with the contractual requirements as to form, i.e. sending it to the correct email or postal address. Diarising is therefore extremely important. Be alert to the issue of business days in GCT contracts, as in some months the IVD will not be a business day, and this has a knock-on effect for all the dates in the payment cycle, including payment notices and PLS notices. Lastly, appropriate records should be maintained throughout the life of the project, creating a contemporaneous history of events. The availability of records can have a significant bearing on the outcome of cases, so it is essential to maintain an accurate and full suite of documentation. For example, a record of emails, sending payment applications or notices will be one of the first things your advisor will look for and ask for when they're looking at your prospects of a smash and grab adjudication. Fundamentally, a contract is only as good as its user. Whatever contract and mechanism you are operating, make sure that all the steps and timings are complied with. An effective framework for enhancing payment security embraces the 4 certainties: timing, amount, enforcement and recovery. Complying with the processes we have outlined today will help you to contract for both certainty and amount.
We have now come to the end of our webinar, which we hope has been useful to you. We're actually right at the time, but we will take a question quickly. So one of the questions that we've been given today is, can you discuss the requirement for PLS notices when applying LDs? In answer to that, it's that you need to make sure when applying liquidated damages that you have all the information that your contract needs for those liquidated damages. We would recommend setting the calculation out clearly so that you have all the information there. Basically enough that you satisfy that test, which is the basis on which that sum has been calculated. It is common that liquidated damages are included in a PLS notice, but they might also require additional notices, so you'll just need to check your own contract. There are a few other questions we can't get to, but we'll respond to those separately, and also feel free to drop us an email with any questions after this webinar. We'd also just like to take the opportunity to remind you this is the first webinar in a 3-part series, and we do hope that you join us for the next one on Tuesday the 5th of November to discuss variations and compensation events.
We will also be running a number of breakfast seminars, so please keep your eye on emails and on our website and sign up to those if you would like to come along.
Thank you. We look forward to welcoming you to future webinars and seminars.